It's a small step for the Supreme Court, it's a giant step for women.
I think the kind of practices that were going on was something which was derogatory to dignity, to equality.
Jan welcomes the judgment of the Supreme Court by a 3-2 majority to strike down triple talaq.
ये एक धार्मिक मुद्दा कैसे हो सकता है? ये एक सामाजिक मुद्दा है।
जो 3 साल से जद्दोजहद चल रही थी हम जैसी औरतों के लिए, मुझे बहुत खुशी है कि उन्होंने जो भी फैसला दिया है हम जैसी मजलूम औरतों के लिए दिया है।
आज का दिन हमारे लिए बहुत ही खुशी का दिन है।
इसके ऊपर एक कानून बनेगा और उसके लिए हम बहुत ज़्यादा उम्मीदें सरकार से लगाते।
A Supreme Court bench comprising 5 judges, all of different faiths, has struck down the practice of instant triple talaq. The Supreme Court bench, in a 3-2 majority verdict, ruled that talaq-e-biddat, the controversial Islamic divorce practice where a Muslim man can divorce his wife by simply saying talaq 3 times in one instance, is illegal and unconstitutional. The Constitutional Bench heard 7 petitions filed by Muslim women challenging the age-old practice. One of these petitions was by a woman who was divorced via WhatsApp. Well, over the next half hour, we will be talking to legal experts to understand whether this landmark judgment can be a precursor to abolishing other controversial practices, or at least put them under the scanner. But before that, my colleague Ashmit Kumar is standing by to just take us through the details of this judgment. Ashmit.
Well, let's go through the fine print here. There was a fair bit of confusion in the morning, but now with the order copy coming out, there's much more clarity. It's clear now that there was a 3:2 ratio as far as the dissenting verdict was concerned. Let's first take you through the minority view, and this view was expressed by Chief Justice Justice Khair as well as Justice Abdul Nazir. The broad takeaway, the message that is sent out as a part of the dissenting verdict essentially is that as far as proactive judiciary is concerned, it is important to keep in mind that there can be no egalitarian approach going forward, especially on part of issues, especially in context of issues that are a fundamental part, that are an integral part of religion. What the order essentially says, this of course is the dissenting part, is that talaq-e-biddat is a crucial part, is an integral part of Sunni Muslims. What the order also does, it also goes on to say that as far as triple talaq is concerned, this dissenting order does not find it to be violative of fundamental rights. In fact, it goes on to say that talaq-e-biddat is in fact is tantamount to the same status as fundamental rights. Which brings us to the majority view. Now, this is the view expressed by none other than Rohinton Fali Nariman, Justice U.U. Lalit, as well as Justice Kurian Joseph. Let's take you through the majority view, and this is the view that shall now prevail, given that it is in majority. First up is, of course, the sense that we get from Justice Kurian Joseph. He clearly says that as far as this is concerned, as far as talaq is concerned, it's not only against the tenets of Quran, but is also against the tenets of Constitution, that it cannot be permitted. It also goes on to say that no constitutional protection is provided to such a practice of talaq, and finally concludes by saying that it is not for the court to direct any form of legislation at this stage in terms of tackling the menace of triple talaq. That's, of course, Justice Kurian Joseph. As far as Justice Nariman is concerned, the sense that he gives as a part of the order is that triple talaq is an instant, and an irrevocable part, and that is sufficient grounds for it to be struck down. It also goes on to say that there is no room for reconciliation available, and that is again a basic flaw as far as triple talaq is concerned. And finally going on to say that as far as triple talaq is concerned, it is void of any protection in law and hence deserves to be struck down. So that's the sum and substance of the landmark order. 3:2, the majority view prevailing that triple talaq in its current shape and form has been struck down by the apex court of the country. Back to you.
Thank you very much, Ashmit, for summarising the majority and the minority view. And on this historic judgment, CNBC TV 18's Anshu Sharma caught up with senior lawyer Kapil Sibal, who represented the All India Muslim Personal Board in this case. He says, of course, he welcomes the judgment. Here's an excerpt of that chat.
We welcome this because what is set aside is a particular form of talaq, that is instantaneous talaq, by the husband repeating talaq, talaq, talaq thrice. The other two forms of talaq, talaq-e-Hasan and talaq-e-Hasan, there is no impact of the judgment on that. In fact, the majority view is that personal law is protected and it cannot be tested under any articles under Part 3 of the Constitution. That's the majority view of Chief Justice Kher, Justice Nazir and Justice Kurian. Justice Kurian strikes it down, not for the reasons that Justice Nariman and Justice Lalit strike it down, but on the ground that this doesn't form part of the Quran. And Quran doesn't recognize triple talaq in this form.
How do you balance the right of minority religious group to right of women?
There's no question of balance. The rights of women should always be protected.
Okay. Well, to discuss this landmark Supreme Court judgment further, joining me now is Mr. Mahesh Jethmalani, a senior advocate at the Bombay High Court, and Mr. Mohan Parasaran, former Addl Solicitor General. He joins us on the phone line. In a bit, we are going to be joined by other guests as well. Gentlemen, good evening and thank you very much for joining us. Mr. Parasaran, sir, I don't know how much of the judgment you could read, but is this something that is incumbent on a law being passed by Parliament, or is that the minority view, that irrespective of the law being passed by Parliament, this is a law, triple talaq, is unconstitutional?
See, my understanding actually the majority view. Last paragraph, in unequivocal terms, has said triple talaq is actually unconstitutional.
Okay.
And Korean also has actually has actually taken that it is not part of personal law, and it is not shared by the other four.
Okay. Okay. Well, we have you on a scratchy line. We'll try and redial Mr. Parasaran. Mr. Jethmalani, how did you understand the verdict? Done and dusted and now no going back? Or does Parliament have to come with a law in 6 months?
No, not at all. The court itself has stepped in. The majority itself has held triple talaq to be illegal. The two judges, Justice Nariman and Justice Lalit, have said that it is part of Sharia law, but because it is arbitrary, and it is arbitrary because talaq can be pronounced without reasonable cause, and also without any chance of reconciliation because it's so instantaneous. And therefore, it's arbitrary, violates Article 14, and even though it's part of Sharia law, it should be, it is liable to be struck down. As far as Justice Kurian is concerned, he takes a slightly different view. He says triple talaq is neither part of the Quran, nor is it a part of the Sharia law. He follows the judgment of Shamim Ara, which was passed recently and followed subsequently in many other judgments, and says that since it's not part of Sharia and it's not part of, it's not ordained by the Quran, it is illegal. It is clearly illegal. So, as of now, triple talaq is both constitutionally and otherwise illegal.
Okay.
And well, just by the way, Kapil Sibal said, I heard Kapil say that what was decided was only the triple talaq and not the other two forms of talaq. The only issue before the court, brought by the petitioners was the issue of triple talaq. Okay. And that's why it was restricted only to triple talaq.
No, actually, that was going to be my next question, Mr. Jethmalani, because immediate or instant talaq has been, or triple talaq as you put it, has been held unconstitutional. Would the non-instant talaq, the other triple talaq, be valid?
Well, yeah, you're right. This is instant talaq, not triple talaq. All forms are triple talaq. But this is instant talaq is what they call talaq-e-bidat, and that was before the court. That alone has been held to be unconstitutional or illegal. The other two forms, talaq-e-Ihsan and the other form, talaq-e-Hasan, these two have not been touched at all, and they continue to prevail as part of Muslim personal law.
Okay, Mr. Parasaran, is it just a matter of challenging it now? Can the logic of instant talaq being banned be extended if somebody were to bring that to the court? Is there sufficient fire in the judgment to merely extend that and, ban other forms of triple talaq?
Yes, of course. Going by the judgment of Justices Nariman and Justice Lalit, I think there is sufficient fire because they have invoked both Articles 14 and 15. Therefore, I think there is sufficient fire in other forms.
And it's only a question of
other forms of talaqs also.
Okay. Well, your call, Mr. Jethmalani, it's just a question of someone else now making that petition?
No, I think, look, the judgment was restricted to talaq-e-bidat, instant talaq. They said that that is arbitrary and therefore violative of Article 14. And on that simple, and the reason, as I said earlier, was why they found it arbitrary was because it didn't give a chance for reconciliation. It became instantaneously irrevocable. And also because it could have been done at the whim and caprice of the husband. And so it was whimsical and arbitrary.
Okay. No, I'm asking you because was there any mention, and again, I have not read the judgment, nor am I qualified to understand all its legal ramifications. I'm asking you if Article 14 was called upon and placed as superior to, Articles 25, 26, 27 in any fashion. In the sense that can we extend this to say that the woman can also ask for divorce? Under Muslim personal law, at the moment, she can ask for khulla. She cannot ask for divorce. So can this judgment, Mr. Parasaran, be used to push the envelope on gender bias? At the moment, we are discussing Muslim personal law. I'll come to all personal law and all gender bias. But for the moment, can this judgment be used as a basis to push the envelope and say all forms of triple talaq, and for that matter, even the right of a woman to ask for divorce can be supported? Anything in that judgment, Mr. Parasaran?
That's what I was saying. From an argumentative perspective, from the viewpoint of Article 14, to which only 2 judges were parties, yes. But I think the other 3 judges, I think Justice Kurian did not specifically agree qua Article 14.
Okay.
Yeah.
Well, Mr. Jethmalani, do you think Muslim women are on the threshold of getting that? If 2 out of 3 have agreed, then probably it's only a matter of perhaps more persuasive argument or a matter of time before even that will be admitted by the judiciary. Are we in the throes of achieving that kind of a change in Muslim personal law?
Well, there's no reason to make that inference from this judgment, because when the Supreme Court struck it down on the ground of Article 14, it did not talk about gender equality, so that women could have, a corresponding right of talaq. It didn't put it on that ground.
Okay.
It put it on the ground of that facet of Article 14 that prohibits arbitrariness.
Okay.
The law pertaining to Sharia and instant talaq was arbitrary because it was whimsical. It left too much to the whims of a husband. So, it didn't say that the same thing should be offered to a wife.
Okay.
But that's arguable, and maybe, at a different era and with more progressive people in this country, it may happen.
Okay. Well, actually, Mr. Parasaran says that anyway 2 of the judges actually, relied upon Article 14. And therefore, if 2 out of 3 have, then that's still gives one hope. Actually, we are now being joined by someone who makes even our debate a little even-handed in terms of gender bias. Additional Solicitor General Pinky Anand is also going to join us in just a minute. Let's do one thing. We'll take a very quick break, and then this becomes a more gender equal debate. We are back in a jiffy.